Good morning to each and everyone. Thank you very much again for being here. We are going to listen just in a few moments Péter Paczolay with his second lecture. After having devoted yesterday's class to universalism and relativism of human rights, today the subject is quite comprehensive and challenging, whose title is The Role of Theories of Sovereignty, Consensus, Margin of Appreciation and Subsidiarity in the Interpretation of Human Rights. So I'll leave the floor to Péter Paczolay, thanking him again for being here. Thank you.
Thank you again, and thank you also. And thank you also for you that after a few hours you returned to continue listening to me. Yesterday, really I drew just a few conclusions that I addressed yesterday, the problem of how the natural rights were turned into enforceable positive rights. Then I pointed out some inherent contradictions that, for example, between universality, between the relativism, then universality of human rights and the regional, cultural identity of human rights and the particular states' special human rights concepts. Also try to present some ideas, some efforts for the reconstruction of the human rights after the inflation and the deconstruction of the human rights that ended up in the relativism. I spoke with a realistic approach on the new developments like human rights and business initiative. And now I'd like to, as I promised, leave a little bit aside the theoretical, abstract level and go to more concrete examples of the same problem of universalism and state sovereignty, and especially within the practice of the European Court of Human Rights, where I am for the moment the Hungarian judge. So the tension between the concept of universality of human rights and the implementation of this relevant international convention, among them the European Convention of Human Rights that I addressed yesterday, at the state, how this is implemented at the state level, this actually now can be, we can approach it as the relationship between the universality of human rights and the individual state sovereignty. The implementation of the most important international norms also depends on the will of the sovereign states. So we spoke of the ideal of the universality of human rights, but we cannot realize them without the sovereign states where the citizens, where the individuals that are subject of these rights are living. International organizations have only limited powers to monitor the implementation of human rights. The international community and its agencies are unable to prevent even the most serious human rights violations that I mentioned, the genocides, war crimes, even in Europe, crimes against humanity, in mass violation of human rights and so on. And what's really the problem? That the mass occurrence cannot be obstacled by the international agencies and organizations. So despite the decline of sovereignty, because that's true that at the end of the 20th and especially the 21st century, the original concept of sovereignty as the absolute will of the power of the state has changed. So state sovereignty became limited by a lot of institutions. Nevertheless, the international community's intervention in violation within the state remains ineffective without the involvement of the state itself. The reason is that international law and international organizations are defenders of the theory of the state based on the inviolability of sovereignty. So the international law itself accepts the inviolability of state sovereignty, and this leads to heavy casualties in the international communities. like the dilemma of humanitarian intervention into a country where mass violation of human rights occurs, like it was in the early 90s in former Yugoslavia in Europe, or let's say in Rwanda is one of the examples mentioned very often. So there are two basic problems of the humanitarian interventions are the failure of the action and its two-phase nature. In two-phase nature, I mean that the fact that provides a kind of legitimacy to the violations, saying that the international community intervened, but nevertheless, what we see in a lot of places in Africa, that the violations continue. I mentioned yesterday, also already in the context of the human rights and business, that the doctrine of the responsibility to protect has been emerging recently, which would allow the international community to take effective action to protect citizens of the state concerned in the event of serious human rights violation. European Union developed, say, generally perceive and accept the need for a new way of reconciling state sovereignty and the international community's responsibility to protect human rights. However, most developing countries perceive the doctrine as a new guise for humanitarian intervention and likewise reject it, opposing it with the good old principles of sovereign equality of the states and non-interference in domestic affairs. There will be no solution in the progress until, in my view, we not abandon the rigid interpretation of sovereignty. Even we see within the European Union, certain states, certain governments return continuously to the idea of state sovereignty against Brussels, against the European Union, and so on. And whatever, in my view, the Westphalian state system and that kind of international law and political practice is over, not only in the European Union, but where the member state voluntarily offer some parts of their sovereignty to the supranational organization, but in generally, theoretically as well, I am convinced that this kind of state system is over, even if certain political programs, certain politicians, certain governments insist on referring to the original state sovereignty philosophy. So the states no longer have unlimited sovereignty over their internal affairs, either politically or legally, not speaking of economically that I mentioned yesterday regarding the transnational economic organizations. A new solution to the relationship between national sovereignty and international responsibility is essential to further development of the universality of human rights. Indeed, the universality of human rights cannot be legitimately invoked only in the case of the most serious violations, since the scope of protection of these rights is much broader. In this broader context, also true that those who in human rights debates brush aside the experience of history and the present, defend to the hill the unlimited sovereignty of the state, reject international responsibility, and consequently they deny above all the moral foundations of a new international system. That the cause of human rights as a matter of innate rights of all human beings cannot depend solely on the political will of the governments of the day. That would be the answer to this approach, still based on state will and state sovereignty. A debate on the concrete content of human rights and the consistency of international accountability does not give anyone the right to question these moral foundations. There is room for debate on specific issues before international fora, since they are a common concern of the international community, and not the dictators of individual states, individual actors, governments. But no one should question the legitimacy of the international responsibility. So now let me turn to the European commitment of protecting human rights and the relation of national sovereignty in the everyday practice of jurisprudence of international and domestic courts. In contrast to the ineffectiveness of global institutions for the protection of human rights, the European mechanisms for the protection seek to defend the rule of law, democracy and fundamental rights through several fora. The decisions of the Council of Europe. The Council of Europe basically creates soft law. Generally, the Parliamentary Assembly, all the other organs give recommendations to the states. Nevertheless, these are decisions that at least should be taken into consideration at least. But then the European Convention of Human Rights is abiding for all the member states. They accepted it. And the European Court of Human Rights can enforce those fundamental rights that are in the European Convention and its additional protocols. The decisions of the Strasbourg Court are binding in concrete specific cases, and controversies are binding on the member states. And even if they are not binding on the courts of directly on the courts of the member states, so the domestic courts don't have to follow literally what the Strasbourg Court decided. But of course, if there is a consequent jurisprudence by the Strasbourg Court, sooner or later either the domestic courts might follow it, or the legislator has to intervene, amend the law, etc. So anyway, that's the judgments of the Strasbourg courts are binding on the states. That means that they have to execute the judgment, to pay just satisfaction to the applicants. It's not binding directly on the domestic courts, but as they say it in a rhetoric manner, that it's a source of inspiration for the domestic courts, so at least domestic courts might take into consideration what is the practice of the European Court. Of course, these judgments, the decisions of the European Court of Human Rights, as the judgments of all courts, is sometimes very severely criticized. Myself, as yesterday came out during the discussion, that myself I'm also critical with quite a number of judgments of the court, and I don't hide away my opinion on that. But of course, this criticism cannot be based on the rejection, cannot be based on challenging the common moral principles on which the convention is based, but it must take rather a form of, as we used to say, a form of dialogue, a civilized way of expressing criticism, asserting interests, or arguing for one's own position. The criticism against, now going concretely to the Strasbourg Court, which of course is not the only court, human rights court in Europe, because the European Court of Justice, that's at the times of the common market, basically a court dealing with economic matters. In the recent times, recent decades, became also a human rights court. And personally saying, when I was a candidate to become judge in Strasbourg, as I spent my life since the 80s dealing, as I mentioned yesterday, I spent my late 70s and early 80s with dealing with state sovereignty and with the power of the concept of the state, with Machiavelli and so on. But then from the second half of the 80s, I was dealing with human rights, very concretely with religious human rights, so to say, also in the underground opposition of the socialist system. So I spent later on, as you could hear yesterday, my life serving human rights, to say it pathetically. And for us, for me, the law of the European Union is quite alien. When I graduated, we didn't know basically anything. Know that exists in the common market, that was all. So I was under pressure in Hungary that instead of going to this Strasbourg courts, I should go, as one of the leading politicians told me, my former student, you should go to the serious court, should go to Luxembourg. Then Koen Leenaerts, who is the president of the Luxembourg Court, called Court of Justice, and an old friend of mine since the late 80s, he also tried to persuade me to go to Luxembourg because they are now a human rights court and they need professors and experts from human rights field. But I told him that I am quite old, I don't know European law. You speak of human rights, but what's the guarantee that I have to deal with human rights and not with the rights concerning banana size and so on? So I rejected this idea. But I mentioned that also the Luxembourg court is now very strong on human rights, as we can see, on how to say, also to interfering to a certain extent to the political solutions taken by governments. Of course, the enforcement ground of the Luxembourg court is more serious because the European Union is also a source of money for the countries, while the Council of Europe only takes away money from the countries. So that's, of course, also creates some certain consequences. But returning to the Strasbourg court, criticized because of the activism. On the other side, quite a few people accept and recognize that the Strasbourg court practices really self-restraint, respect for the decision of the domestic courts and authorities. So the evaluation of the Strasbourg court is two-phased in this sense. Let me mention just some of the arguments regarding the activism of the court. The first is a doctrine that was elaborated by the court, the so-called living instrument doctrine. The living instrument means that the court, of course, I have to remind you that this court had two very distinctive periods in its history. It was created to execute the convention that was signed in 1950 in Rome, in the Palazzo Barberini, and then the court was created after a long procedure in 1959, and the first judgment of the court was delivered in 1960. And that time, the individuals couldn't go to the court directly. They had to apply to a commission. There was a twofold system, Commission of Human Rights and the Court of Human Rights, and only the Commission, or in special cases, the states, member states themselves could go to the court. And anyway, that means that the Commission had a very serious filtering functions, not by accident that between 1960 and 1998, some 800 judgments were delivered by the Strasbourg court. Nowadays, we deliver 2,500 judgments a year. So, and then another issue was that the state had to consent to the procedure. And thirdly, the national judge, I will address this issue a little bit later, the national judge was basically the rapporteur in the issue, so the judge from the country the respondent country was the rapporteur in the case, which is something very, very strange because we have still this practice. Then, after the enlargement of the Council of Europe from the original 10 countries, they arrived to 47 countries, 47 included also Russia, today 46. Then it opened up, after the reform procedure, the possibility in 98 for individual applications for all not only all the citizens, but for all people who were on the territory of the member states, or in some way the member states violated their rights, therefore came human rights cases to the court, for example, violation committed by British troops in Afghanistan and so on. So this, and I remember in Hungary, and it was we were the first country, the former socialist countries, to join the Council of Europe, and from '93 also we the members of the European Court of Human Rights, and there was a great expectation in the population, despite that we had a very effective constitutional court. But the Constitutional Court at that time in Hungary exercised basically abstract review of the laws. The individual application arrived very difficult. It was actio popularis, so anybody could go to the court, but with the demand that this piece of legislation is unconstitutional, and was very difficult, to remedy the individual violation of the person by the Hungarian Constitutional Court. So they started to go to Strasbourg, but it took quite a time when the first judgment by the court was delivered in a case that I will address also on your demand a little bit later. And so at the beginning the court thought that should be stuck to the original text of the convention and to the, let's say, to the travaux préparatoires, the ideas beyond, so the originalist interpretation of the convention. But very soon, even during this first period, the judges decided to move away from this, what we could call generally the original intent interpretation, and consider the text of the convention as a living instrument that can be interpreted according to the present situation, according the changes of the life. Let me quote how it was originally formulated in 1978. Quote, "The court must also recall that the convention is a living instrument which must be interpreted in the light of present-day conditions. In the case now before it, the court cannot be influenced by the developments and commonly accepted standards. Nevertheless, it exercises this, it can deliberate on whether accept the changes in the standards of whatever, in this case of the penal policy, or not." So, as usual, here the court opened up two ways. First of all, stating that it must interpret the convention in the light of present-day conditions, but it's for the court to decide whether the developments, this present-day condition, influence the former practice, the former case law, or not. This one step left, one step right, this you will see that very often comes out as a how to say, the interpretative policy of the court. Nevertheless, the court is stuck to this formulation. Let me take one from 2011, a more concise form. It says, "The court reiterates that the convention is a living instrument which must be interpreted in the light of present-day conditions and of the ideas prevailing in democratic states today." This living instrument is not only criticized in itself, that this basically opens up the interpretative methods almost arbitrarily for the court. It's also criticized because the court limited its interpretative methods to the living instrument doctrine and rejects the original intent or any similar doctrine, even if they used sometimes, mostly earlier, the preparatory texts of the convention, etc. But the one way of criticism is that basically abandoned completely other ways of interpretation, namely the textualism and the original intent interpretative methods that are used widely by other courts, constitutional courts or American courts, etc. The following activist approach developed by the court itself was the so-called evolutive interpretation or integrated approach. And this is one of the problems that we addressed yesterday, speaking of the different generation of human rights, because originally the convention had like a dozen fundamental rights, like absolute rights, right to life, prohibition of torture, then the classical rights, freedom of assembly, freedom of expression, freedom of religion, etc. Some, how to say, more peculiar rights, like the right to marry, etc. But then was limited definitely to fundamental rights. Later on, in the first additional protocol, they introduced the right to property, as I mentioned yesterday. But basically, still the convention, with the exception of Article 1 of Protocol 1, the right to peaceful exercise of possession, it contains classical freedoms and rights and elaborated on those issues like discrimination and so on, nebis in idem, prohibition of double punishment and so on. But this, how to say, the court realized that nowadays the social rights have a sometimes much more importance than the classical fundamental rights. And then the court opened up at least the interpretation of certain cases towards the social rights using a document that was adopted by the Council of Europe, namely the European Social Charter. Somehow the European Social Charter, because the court dealt with more and more, especially with the accession of former socialist countries, with labor law issues, with pension issues, and so on. For example, in one case, and this is the problem of the Baltic states, especially of Lithuania, Latvia, and partly of Estonia, that mostly Lithuania and Latvia had a lot of problems with the citizens who were not Latvians or Lithuanians, but Russians were living during Soviet Union times on the territory of these two states occupied by the Soviet Union, and they were working there. And after the changes, both countries introduced, so to say, not to say a legal evaluation, but so to say discriminatory laws regarding the pension and even the employment of those citizens who came from the Russian territory, and these issues came to the court several times. But here we speak of employment, we speak of pension. So there, for example, in one Lithuanian case, 2004, the court was dealing with the employment restrictions on former employees of the KGB, of the Soviet Secret Service, and the court found violation that Lithuania violated the convention by discriminating in the employment of citizens, especially Lithuanian citizens and former KGB employees, and to enforce its argument, the court cited the European Social Charter, the Super Social Charter, saying that with a view to ensuring the effective exercise of the right to work, the parties undertake to protect effectively the right of the worker to earn his living in an occupation freely entered upon. And this provision, that was quoting from the judgment, this was basically word by word taken of the Charter of the European Social Charter of 1996. And then the court consistently interpreted the social rights and establishing a right not to be discriminated against in employment. And the non-discrimination guarantee is of course in the convention, but in this sense for the employment rights is in the charter, the social European Social Charter. So here the court said that this is an integrates other instruments by the Council of Europe to the interpretation of the convention. This was also taken as an activism of the court, this kind of evolutive or integrated interpretation where it opened up the way to social rights, labor rights, employment rights, etc. Yesterday I mentioned, I don't want to repeat it, that one of the signs of the activism of the court is that the court gradually extended the negative obligations of the state, so this classical view of defending the individual's rights against the state, to the positive obligations of the state when the state is required to act in order to secure persons within its jurisdiction. And as I quoted yesterday, here the court must strike a fair balance between the general interest and the interest of the individual. Then yesterday I mentioned, just recall again, the pilot judgment. The pilot judgment is not in the text of the convention. So you can show that the convention and the amendments, the additional protocols to the convention are born in a very difficult procedure. The member state, as you can imagine, 46 or previously with Russia, 47 member states with so different backgrounds and traditions, etc. This negotiation procedure is very hard, takes long time, so it's not easy to amend the convention or to accept the additional conventions that amend it. And therefore it's very important what is in the convention is really the result of a very hard and long deliberation procedure. Therefore, what is not in the convention is always suspicious, because that was invented by the court. Nevertheless, a lot of instruments were invented by the court that finally accepted by the member states, even if were not negotiated through the original ordinary procedure. I mentioned yesterday the pilot judgment. The pilot judgment is not in the text of the convention. The quotation that I read you yesterday in this Polish case regarding the abandoned territory, the compensation for the abandoned lands, was basically arguing by Article 1 of the convention. Article 1 of the convention says that the judgments, that all states abide in protected to the court in protecting human rights. So the most general provision of the convention, and on this it says that all states shall secure to everyone within its jurisdiction the rights and freedoms defined in the convention. And on this base, the court introduced the general duty of accepting positive obligations to ensure the effective exercise of rights guaranteed by the conventions. And this against, let's say, a third way of accusing the court of activism. And then let me mention finally another instrument, but this is not a interpretative methods, not also the pilot judgment, that the pilot judgment's main mandate, main function is to solve 1,000 of similar or the same applications by the applicants. What created, probably also new one from the news, there is not a specific, not interpretational method, but a specific procedure. It's a specific procedure. This is the interim measure. The interim measure is regulated by rules of the court, the famous Rule 39, introduced like 20 years ago and used the everyday practice in the court. I have to say, I'm always wonder why this state accept. Of course, what does it mean, interim measure? This is a special tool that is used in a limited nature, so mostly for the so-called absolute rights, right to life, prohibition of torture, and this is applied when there is an imminent risk of irreparable damage, and then the court applies Rule 39. Other international courts have similar measures, also the European Court of Justice, the European Court of Justice, Luxembourg Court uses when the serious and irreparable damage is then can use interim measure, but that is regulated there. Here it is not regulated. The court introduced on the model of other international courts, and basically the member state accept that there are really certain situations when the ordinary procedure before the court would be ineffective because, let's say, the applicant would die in the meantime, or the applicant would be executed in the meantime, and so on. So therefore, still there are, even within the court, there are discussions about the use of these interim measures. The problem is that recently the court enlarged the scope of these interim measures from these basic issues when, for example, people to be extradited or deported back to countries where there was the danger that they will be ill-treated, even if executed and so on, or someone has the serious illness, and then we say the interim measure that he, despite that he's criminal, he's in a prison, etc., that he should be cured and not wait until the court decides at the end, and so on. So this more or less the governments execute it. There are special departments in the Ministry of Justice and so on. When we send, also we receive from Italy a lot of requests. I was duty judge for years, among others also in respect of Italy. In Italy, it was mostly the applications regarded the very bad health situation of prisoners or not that specific medical treatment that they need for their mental or other health and so on and so on. But what was a scandal in the United Kingdom, like a year ago or less, was this, how to say, deportation of illegal migrants to Rwanda, with a strange arrangement between the British government and Rwanda that Rwanda will accept illegal migrants. And then it was maybe not clear from the news that we speak only eight migrants that were to be deported to Rwanda, and 3 of them applied for interim measures not to be extradited or deported to Rwanda. The duty judge rejected one request and gave two other requests, but then the flight was stopped. But basically not because of the Strasbourg decision, but because they went to the domestic courts, and their application before the High Court was pending. So therefore they blocked the flight. As regards the Strasbourg interim measure, they could took off from the airplane the two guys who were given the interim measures, and then go with the other 6 to Rwanda. Instead of, they made a huge scandal, and then they were also investigating who was the duty judge, because the court had a very, I didn't agree with this solution, that you can see on the homepage of the court who are the duty judges, because there was an asterisk at the name of the 3 duty judges. But you don't know who signed the decision. There were 3 duty judges, the British, the judge from Liechtenstein, and myself. So they reduced the suspicion to 2 judges, because they knew that the English judge cannot decide on English requests, and they were following us. I was on the front page of the Daily News as one of the possible 2 criminals who committed this crime against the United Kingdom, and so on and so on. And I cannot share with you the whole truth, so they were right. One of us signed the decision. I cannot say whom of us, but it does not make difference, because we would take the same decisions. 3 of us were collaborating quite closely. The problem with the interim measure is that the court tried to enlarge its scope, first to freedom of speech cases, like, and when in Georgia, the government wanted to close down a radio station, and then the court intervened with interim measure not to close. And this freedom of expression was not within the scope of interim measure of the imminent risk of irreparable damage criteria. And recently, and this is a much serious problem, that they applied continuously interim measures in the case of the Polish judges who were suspended by the National Judicial, or by the Minister of Justice, or by the Judicial Council, which I, honestly speaking, I don't see what is irreparable damage if a judge is suspended for 6 months and receives only the half of his salary, because in my view this might be repaired later on, and definitely there is much different when someone's life is at stake if he's deported or extradited, and not that he's suspended for 6 years, but that became the practice of the court. That also was basically not, even it's not clearly rejected by the Polish government. The Polish government asked the court that what should then they do. So what is the court should explain them what to do. Place back the judge to his previous position, etc., and so on. So basically they ignore the judgment of the court. The United Kingdom went much more far. They are frightening the Strasbourg court that they will leave, among others, because of the activism of the court, and secondly because of this interim measure, the Council of Europe, which I mean would be really an irreparable harm and damage, in the sense that basically the whole Council of Europe was a British idea. Churchill was the promoter, and so I mean after Russia, the United Kingdom would leave the Council of Europe. That's, at least for me, so my private impression would be really an irreparable damage. So that's for the activism. As regards the restraint, we speak the restraint. I don't say that activism is negative. Restraint is positive. Activism has its very clear role. this living instrument method, has its advantages, etc., etc. It's a legitimate way of interpretation, even in other. What regards the restraint, that also is one approach that is very sharply criticized, sometimes by the judges themselves, the more activist judges. It's criticized also from outside, so there's a huge literature who, let's say, accepting that the court really exercises serious self-restraint, nevertheless the self-restraint sometimes has a negative effects and so on. So first of all, I'm saying that the court does not exercise only self-restraint, but in the convention itself there are only restraints on the activism of the court. First of all, the convention gives possibility of reservations. So that any state, when signing the convention or ratifying it, can make a reservation in respect of any particular provision of the convention, saying that any law in force in its territory is not in conformity with that provision. So it does not have to give up that legal provision, but it says that there is a reservation, and for concrete legal instruments, so not generally a reservation against the convention, but concrete reservations can be made. Secondly, it makes possible derogations in emergency situations. This is Article 15 says, in time of war or other public emergencies threatening the life of the nation, any state may take measures derogating from its obligations under the convention to the extent strictly required by the exigencies of the situation, and providing that such measures are not inconsistent with other obligation, other international law. So it's rather limited, but no derogations are allowed by the convention for the absolute rights, for the right to life, except in war, prohibition of torture, prohibition of slavery, and from the nullum crimen sine lege rule. These are considered the absolute rights within the convention, and I mentioned several times. The other non-absolute rights are equivalent and may be limited if necessary during these emergency situations. Recently, the COVID pandemic opened up the possibility for several member states to introduce certain derogations. Several countries used this method. For example, Hungarian government was hesitating to have a derogation regarding one, just to explain what does it mean that there has been a concrete, that for the judgments of the administrative court wanted to ask for derogation, but then they were deliberating. They also on my opinion, etc., etc. So finally, for example, Hungary and the majority of the countries did not use this possibility of derogation during the COVID pandemic. Then, besides this, which I call restraints in the convention itself, there were really the self-restraint tools that were, as the activist tools, were developed by the court itself. Also the self-restraint methods and tools were developed by the court itself. And these methods are the European consensus doctrine, the principle of subsidiarity, and first of all, the margin of appreciation. Now, I will address them. Just let me mention, jumping to the end of the story, that for the moment, the principle of subsidiarity and the margin of appreciation is not only a judge-developed tool, but the protocol number 15, amending, among others, the preamble of the convention, now became part of the convention that the high contracting parties, in accordance with the principle of subsidiarity, and have the responsibility to secure the rights and freedoms. In doing so, they enjoy a margin of appreciation subject to the supervisory jurisdiction of the European Court of Human Rights. So after that, in 2021, the last country of the member states ratified this amendment, it's Protocol 15, and this was Italy. Then it entered into force, and these two principles became part of the preamble of the convention. Although I am a judge, I allow myself to use the explanatory report to this additional protocol that says that a new recital has been added at the end of the preamble of the convention, containing a reference to the principle of subsidiarity and the doctrine of the margin of appreciation. It is intended to enhance the transparency and accessibility of these characteristics of the convention system and to be consistent with the doctrine of the margin of appreciation as developed by the court in its case law. So the jurisprudence of the court makes clear that the states enjoy a margin of appreciation in how they apply and implement the convention, depending on the circumstances of the case, the engaged rights and freedoms, etc. This reflects that the convention system is subsidiary to the safeguarding of human rights at national level. The national level are in principle in better position, better placed than an international court to evaluate local needs and conditions. That's very often repeated by the court. But, as it comes from the last part of the sentence of the preamble, the margin of appreciation goes hand in hand with the supervision under the convention system. So that means that if the decisions of the national authorities are not compatible with the convention, the court intervenes. Of course, I have to say that now more than 6 years experience, that the court and the judges take seriously these principles and this kind of self-restraint. Of course, this also depends by the individual judges. Some judges are always use also, how to say, like a way of escape, a way of out that difficult problems, yes, it's very borderline, etc. Let's trust the national authorities that they know it better as us, that what's the solution. Some of them, this is a very weak theory that we have to decide ourselves, don't take into consideration of the national authorities because they bias, blah, 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 etc. So there are different approaches, and also there are different periods. During the 6 years I arrived to the court, I found that more activists nowadays, especially when we had a president who clearly stated in his program that now we enter in the age of subsidiarity, after the age of activism. Now I see that the court is much more calmed down, and sometimes for my taste we use this reference to the subsidiarity just to escape tough judgments that might go against the state, etc. So, but anyway, I feel, how say, to more respect for this margin of appreciation and subsidiarity doctrine in the last years than at the time when in 17 I arrived to the court. But it's important, really it's interesting, this European consensus doctrine, but I mentioned for the first. The European consensus doctrine means that when the court has a case before it that involves, especially, for example, moral values, moral situations, and so on, then it's looking whether there is a European consensus on that issue, like abortion, same-sex marriage, etc., or not. Because if there is a European consensus, so, I mean, the majority of the states has more or less the same approach and same practice regarding these moral issues, then they say that there is a European consensus. So also the respondent state in the concrete case might follow this European consensus, and if it derogates from them, then violates the convention. But if there is no European consensus, then the margin of appreciations, I mean the freedom of the state is much wider because there is no European consensus. So each state has to deal with its own tradition, etc. For me, this is a very reasonable institution, a very reasonable doctrine, because here we have, originally we had all the 10 countries, but also those 10 countries were differing. So I mean, the Italian or the British legal system is completely different. The French or the Norwegians, etc. So even the founder states case, then the morals regarding this, the consensus regarding these morally very important issues were different even among the 10 founder states. And imagine now that from the Caucasus to the Atlantic Ocean, how many political, moral, cultural, legal, etc. traditions are mixed together in the Council of Europe. So I think that it's not only a kind of defense for the court, but it's a very rational doctrine to look at the European consensus and give the possibility of deteriorate from the convention for the countries if there is no European consensus on the concrete case. And of course, this is always mentioned that this is a balance against the balance between the European supervision of the domestic violations of the human rights and respect for the state, or let's say clearly respect for the state sovereignty in this sense. So that means that this interpretation by the court means that the convention concepts are to be regarded as parts of a self-governing legal system that must be interpreted independently from the legal system of the member states. But the consensus should not necessarily mean the consent of all the parties affected or of the member states. So this European consensus means rather a common ground or a common denominator, let's say. Another self-restraint doctrine is very often quoted by the court, that when performing this role, this balancing between the European supervision and the state sovereignty and the freedom of the state to act, the court emphasizes that this court is not a further court of appeal after the domestic courts. It's not a fourth instance court, that's what we used to say, examining simply the rulings of those courts, whether they made an error or not. So neither factually, especially factually, we don't make assessment instead of the national courts. We have the judgments of the national courts, which sometimes they give answer, sometimes they do not give answer to important questions, but we don't ask further materials, we don't ask the file of the internal courts, we just use what is written in the judgment, and we do not revise the facts, and not even the law. We just say that whether compared to the convention, an error was made by the domestic court or not. That's, of course, it's easy to say this here. It's difficult to follow in the practice, because if the judge is, or anyone, I would say, is in the position of the judge, when dealing with a case, it's very difficult to say that, okay, I have very serious questions that would be very important to decide on the case, but I cannot reassess the domestic courts. I cannot ask further questions regarding that, so I stop here. I'm not a first instance court. I don't review, even if I feel completely wrong or unjust or factually wrong the judgment of the domestic courts. I have to stop at this one. If I cannot prove that there is a violation of the convention by the final result of the court, then I don't go further. That's always a temptation to go in the depths of the case, of course, reassess all the elements of the case as a real appeal court or first instance court, and then, so how to say, we have to struggle with ourselves to respect these rules. Here says, for example, the court in a judgment, I quote, "The court has said on numerous occasions that it is not called upon to deal with errors of fact or law committed by the national courts, as it's not a court of first instance, and this is not called upon to reassess the national court's findings, provided that they are based on a reasonable assessment of the evidence." Now then, we arrived to the person of the national judge of the domestic courts, the judge who decides, and who, in the first of all, the national courts and judges and national authorities has to imply the convention and to defend the rights in the convention. So what's the meaning of the national judge? Of course, there is a specific meaning that a national judge, in the language of the court, is the judge who was elected in respect of the member state, who is not necessarily a citizen of the member state. For example, the judge for Liechtenstein is a Swiss citizen, but he was candidated or appointed as candidate by the respective state, and then he is the national judge for that state. As I mentioned, that this has several consequences in the everyday work of the court. First of all, there is one judge for each state, which is a real source of serious problems, because some countries have more than 10,000 applications, some countries have 2 or 3. And there is one judge to deal with all these cases, because the problem is that, as I mentioned, and this is the heritage of the original start of the court, that the national judge is generally the rapporteur in the case, was in the defense of the sovereignty of the founding states. Secondly, is practically because the national judge at least understands the language of the state, and possibly knows the legal system of his or her own state. But the problem is that despite that, judges must withdraw from the case if they already were involved in the same procedure at national level, etc. Therefore, I had to withdraw myself number of cases, especially in the first years, that were already before the Constitutional Court in Hungary. And then the problem is that if of course, one judge with the 10,000 applications cannot deal with all the cases. So then things are assigned to judges from countries from low number of applications. And nevertheless, the judge remains the so-called national judge, who has to make observations on the case. Sometimes it takes more time to convince the judge rapporteur from another country. He probably does not know the language, does not know the legal system, etc., to convince that his approach is wrong. So it sometimes takes more time. So that is a problem that cannot be solved, that judges from this very high number applications countries have to deal with those cases, those judges coming from low number of countries cannot really help them and speed up the procedure. For example, I withdrew from a case, it was before the Grand Chamber. The lawyer who prepared the draft was a Slovenian. The judge rapporteur was from Bosnia-Herzegovina, and the national judge was Icelandic. And they prepared a draft in a Hungarian case. And so sometimes that's bizarre, anyway. So, but let's leave aside the national judge, but let's go to national judge as the domestic judge. So the domestic judge has a very important place in the convention, as of course the national judge is expected to apply the convention. Of course, this is told so, but it's not done so, because what are the problems? The problems also depends on where the convention stands within the hierarchy of laws in the domestic system. Because in certain countries, it's at constitutional level, like in Netherlands and in Austria, that's clear for the national judge that he has to apply even against the ordinary laws of his country. In other nations, like France, Spain, Portugal, Belgium, it's higher than the ordinary legislation, but does not achieve the constitutional levels. It's lower than the constitution, but higher than the ordinary laws. In the majority of the countries, like in Italy or Germany, it has a status of ordinary national law. So then it's not does not have a special and obligatory effect in exercise of the jurisprudence by the national judge. So this then, of course, gives leaves great place for the national judge whether to take into consideration at all the convention or leave the convention aside, or interpret the national law in light of the European Convention's norm, etc. So this of course gives a huge variety for the judges. And let me check, because I don't have neither watch nor sense of time.
20 to 11.
Yeah. Okay, it's 10:40. Then let quickly say a few words on the margin of appreciation, because this is the most debated doctrine used by the court, even now that it's in the preamble, because first of all, when people hear the first time the margin of appreciation, they don't understand what's that. That's okay, there can be a power of appreciation, legal discretion, deference. This deference used very often because it suggests that this is something when the court wants to defend itself from the criticism, or to defend the national legal system or the principle of sovereignty by withdrawing itself from interfering very directly into the legal system of the country. So the court tried to use this difference or this margin of appreciation, saying that there are different legal circumstances, and especially in matters of morals, and also using this argument, and the national authorities better understand this tradition and social perception of morals than an international judge. Secondly, the second ground for using this doctrine is the lack of European consensus, and saying that it enlarges the sphere of action of the state. The margins doctrine was introduced initially in specific matters where there were concerns for the national security of the states. So the government raised this issue that the international policies, international intervention, the legal system can jeopardize the national security. And therefore, in the initial application of this doctrine was in context of derogations from treaty obligations due to national emergencies. That's what I mentioned, which is a restraint in the convention itself. In such circumstances, the interest which the public itself has in effective government and in the maintenance of order justified a decision in favor of the legality of the government approach. So I mean, basically assuming that the government was acting in a right way, and that this original strict approach to national emergency situations and national security problems was enlarged and expanded to other kind of discretion to select policies that would regulate, for example, harmful activities. Then quite soon the court arrived that even in, let's say, speech might be threatened to not to national security, but in some way, for example, hate speech or speech inciting for violation might also be dangerous for the country and would leave free hand for the government to act in its margin of appreciation. So my personal view is that at the beginning it's understandable and it was based on the convention structure, on the way of the derogations and reservation system, to arrive to hate speech in one step that for me is very dubious, and I didn't consent at that time, not even now with that, so I was critical with this approach. First, a judge of the first court said that the margin of appreciation gives the flexibility needed to avoid the damaging confrontations between the court and the member state over their respective spheres of authority, and enables the court to balance the sovereignty of the states with their obligations under the conventions. And then, not by accident, in this large sense, the margin of appreciation doctrine was defined in a very well-known case, the so-called handicide case, when the authorities confiscated a book that was aimed to school children and give them, how to say, sexual education, but the authorities, the British authorities, considered it obscene, that it had the obscene content, and they confiscated the book that was originally translated from Danish to English and published by an editing house. And then the court pointed out that, of course, that the convention is subsidiary to a national system. It leaves to the member state securing the rights and liberties enshrined in the convention. And it's not possible to find in a European conception of morals regarding what is obscene, what is not. The view taken by the respective laws of the different countries as regards morals vary from time to time, from place to place, and especially in our era, was that said in 76, in our era, that is characterized by quick changes regarding these issues, rapid and far-reaching evolution of the opinions. So therefore the court gave a large margin of appreciation to both to the domestic legislator, both to the authorities, among other the judicial authorities, to apply the laws in force and interpret also in light of the convention. But as always, there is the step to the right, that the power of appreciation is not unlimited. The domestic margin of appreciation goes hand in hand with European supervision, and such supervision can be both focusing on the necessity of the intervention by the states into the right, the interference into the rights of the individuals. Then the court also emphasizes that the supervisory function has to pay an attention to the principles of the characteristic of a democratic society. This freedom of expression constitutes one of the essential foundations of a democratic society. It has to be taken seriously into consideration whether freedom of speech can be restricted or not, and under what conditions, and so on. So then the court also says that when accepting the principle of subsidiarity in implementing convention rights by national authorities, it has to take into consideration that in protecting human rights, the provisions of the convention must be interpreted not in a theoretical and illusory way, but rendering the rights practical and effective. Practical and effective, and this also very several times continuously returns in the argument of the court that the rights, the interpretation of rights and application of rights must be practical and effective, not theoretical and illusory. So in my view, margin of doctrine, the margins doctrine sits somehow halfway between the uniform application of the convention, equality to all states, and the domestic protection of human rights. I mean, to leave to the countries how they protect the human rights enshrined in the convention as well. So here the European supervision is combined with the national margin of appreciation, and this might be, of course, considered as a good balancing solution. Of course, the situation is which direction the court moves, to leaving to the domestic authorities the final word, or to exercising strict European supervision. And then this creates a problem and raises criticism against the margin of appreciation doctrine, that it's not applied consequently. But I have to stop at this point, which is no problem, because we meet tomorrow again, and then so we have maximum 5 minutes before we have to evacuate the room. If they have any specific question. I didn't arrive to answer in detail the question of yesterday, but then we'll continue tomorrow. But you can also reserve your questions for tomorrow. Yes, please.
Just a moment for the mic.
Thank you. Okay, it works. Okay, thank you very much for the presentation. The topic is very interesting. I wrote my master's thesis on the court as well, so this topic really interests me. I have a few, but I think I will just ask 2 questions to give space for other people. The first one is that when we talk about the European consensus, I have one doubt, because I think the majority of, especially individual applications to the court, are those who suffer from the lack of legal recognition and protection for some rights that they claim. So they are in the position of the minorities, can be racial, sexual, political minorities. But then the European consensus, as I understood, will take a look into the common direction of the member states of the Council of Europe. And I think they look at the laws that are promulgated for, of course, the general interest of the state, meaning the majority of the state. So I think it's not matching exactly, because on the one side, the national laws are for the interest of the majority, but then the individual applications are usually by the minorities, who of course do not have their interest reflected in the national law. So I would like to hear your insights on this comment. And that leads to my second question. With European consensus, I imagine that there would be someone inside the court who do the comparative analysis of all, I think now 46 member states' national laws. And that not even to talk about, for example, constitution, national constitution, ordinary laws, decrees, etc. I imagine it would be a huge task. And now with the workload, there is, as you said, a few thousands every year that the court handle.
2,000-3,000.
I imagine how will this how can this task be done with the analysis of national laws to see if there is a European consensus or not?
Yeah.
Thank you.
Okay, thank you. With the first question, you touched upon a very sensitive issue. I, by the way, want to address tomorrow because it would be the answer very long. As regards this view, whether protection of minorities, whatever minorities, I mean, the court case law, in my view, this is my personal view, is controversial. Because, for example, regarding the rights of migrants, as vulnerable people, the court developed a strong case law, which is very much criticized by the situation of today, the migration situation today by the member states, and I'm not speaking of East European countries, but Denmark, Netherlands, etc., so Sweden, so countries who do a lot for the migrants. Nevertheless, the court is very tough and arrives to violation because they are vulnerable minorities. Okay. As regards, in my view, the other minorities, then how to say, the balance is controversial, and especially it is in the field of religious minorities. And how, for example, just mention one issue: the wearing of religious symbols in public spaces. That is criticized very much, that it protects when the Christian symbols and does not protect the Muslim symbols, etc. It's I don't know. So anyway, that's controversial. And where the court is really is catastrophic is the ethnic minorities. The protection of ethnic minorities, basically the court does not take into consideration that there are national or ethnic minorities. But I can give some examples for that tomorrow. As regards the practical question, there is a research department of the court with several lawyers coming from different countries, and they make comparative studies. But of course, this is limited because basically they make comparative studies of all grand chamber cases. That's how to say by default, or it's obligatory. And then they, even at the chamber level, the rapporteurs might ask for a comparative study. But in fact, how does this work? The court makes a questionnaire, sends to the Supreme Courts of the member states, the superior court networks, but otherwise it's very effective. They prepare the answer. The answer comes back, let's say, from the Supreme Court of Hungary. I have to revise it and confirm whether it's good or not. And then it goes to this, to the research department that makes a judgment. But honestly speaking, if you look at the Grand Chamber judgment, then you see there the comparative part. Sometimes it's very short, yes, because finally nothing comes out of this comparison. Not all countries answer, so it's different. And then, but in general, the European consensus doctrine that was the basic of this, how to say, doctrine, but it's not. I think it's used less and less concretely in the manner as you were asking. It just is a justification, historical justification, not by accident that it does not become a part of the preamble, because we use as a background theoretical justification for the margin of appreciation, but less and less in concrete cases when they invented for this difficult moral issue of obscenity in the 70s and regarding the United Kingdom. Of course, with the United Kingdom, the relation is always much more sensitive than most of the other countries. Yeah. Okay. So thanks you for today's attention, and tomorrow morning we'll be here again. Thanks. Bye.